大家好，歡迎收聽讀公報。今日讀公報嘅內容係讀美國最高法院推倒 Roe v. Wade 嘅決定，適合英文程度中高級嘅人士。我哋而家開始。首先係 Syllabus 嘅部分。Mississippi's Gestational Age Act provides that, quote, except in a medical emergency or in the case of a severe fatal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being, if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks, unquote. Respondents, Jackson Women's Health Organization, an abortion clinic, and one of his daughters challenged the act in federal district court, alleging that it violates this court's precedents, establishing a constitutional right to abortion, in particular Roe v. Wade, and Planned Parenthood of Southeastern Pennsylvania versus Casey. The district courts granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15 weeks restriction on abortion violates this court's case forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed, before this court, petitioner defended the act on the grounds that Roe and Casey were wrongly decided, and that the act is constitutional because it satisfies rational basis review. Held, the Constitution does not confer the right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers a right to obtain an abortion. Casey's controlling opinion skips over that question and reaffirms Roe solely on the basis of stare decisis. Stare decisis 係一個拉丁文，意思係 the principle by which judge are bound to precedent， 即係法官要遵循先例呢個原則。我哋而家繼續。A proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court therefore turns to the question that the Casey plurality did not consider. First, the court reviews the standard that the court cases have used to determine whether the 14th Amendment reference to liberty protects a particular right. The constitutions make no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. Roe held that the abortion right is part of a right to privacy that springs from the 1st, 4th, 5th, 9th, and 14th Amendments. The Casey Court granted its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's due process clause. Others have suggested that support can be found in the 14th Amendment's equal protection clause, but that theory is squarely foreclosed by the court's precedents, which established that a state's regulation of abortion is not a sex-based classification, and is thus not subject to the heightened scrutiny that applies to such classifications. Rather, regulations and prohibitions of abortions are governed by the same standards of review as other health and safety measures. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of quote-unquote order liberty. The courts find that the right to abortion is not deeply rooted in the nation's history and tradition, the underlying theory on which cases rest, that the 14th Amendment's due process clause provides substantive as well as a procedural protection for liberty has long been controversial. The court's decisions have held that the due process clause protects two categories of substantive rights: those rights guaranteed by the first 8th Amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in Constitution. In deciding whether a right falls in either of these categories, the question is whether the right is deeply rooted in our history and tradition, and whether it is essential to this nation's scheme of order liberty. 問一個權利係咪 deeply rooted in history and tradition， 同埋係咪 essential to this nation's scheme of order liberty， 呢兩個問題係出自 Thames vs Indiana。我哋繼續。The term liberty alone provides little guidance. Thus, historical inquiries are essential whether the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In the interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. Guided by the history and tradition that map the essential components of nations' concepts of order liberty, the court finds the 14th Amendment clearly did not protect the rights to an abortion. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy, and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restriction in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstates this history, and Casey declined to reconsider Roe's faulty history analysis. Respondents' arguments that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. The Solicitor General repeats Roe's claim that is, quote, doubtful. Abortion was never firmly established as a common law crime, even with respect to the destruction of quick fetus, unquote. But the great common law authorities, Breton, Coke, Hale, and Blackstone all wrote that opposed quickening abortion was a crime. Moreover, many authorities assert that even a pre-quickening abortion was unlawful, and that as a result, abortionist was guilty of murder if the woman died from the attempt. The Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening. But the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. Instead of seriously pressing the argument that the abortion right itself is deeply rooted, supporters of Roe and Casey contend that abortion rights is an integral part of a broader entrenched right. Roe termed this right to privacy, and Casey described it as a freedom to make intimate and personal choices that are central to personal dignity and autonomy. Order liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate these interests differently. The nation's historical understanding of order liberty does not prevent the people's elect representatives from deciding how abortion should be regulated. Finally, the court considers whether a right to obtain abortion is part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain abortion cannot be justified as a component of such right. Attempts to justify abortion through appeals to a broader right, to autonomy, and to define one's concepts of existence prove too much. Those criteria, at a higher level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. What sharply distinguished the abortion rights from the rights recognized in the case on which Roe and Casey rely is something that both those decisions acknowledge. Abortion is different because it destroys what Roe termed potential life and what the law challenged in this case called an unborn human being. None of other decisions cited by Roe and Casey involve the criteria moral question posed by abortion. Accordingly, those cases do not support the right to obtain an abortion, and the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. The doctrine of stare decisis does not cancel continued acceptance of Roe and Casey. Stare decisis plays an important role and protects the interests of those who have taken action in reliance on a past decision. It, quote, reduces incentives for challenging settled precedents, saving parties and costs the expense of endless litigation, unquote. It, quote, contributes to the actual and perceived integrity of the judicial process, unquote. And it restrains judicial hubris by repeating the judgment of those who grapple with important questions in the past. But stare decisis is not an inexorable command, and, quote, is at its weakest when the court interprets the Constitution, unquote. Some of the court's most important constitutional decisions have overruled prior precedent. The court's cases have identified factors that should be considered in deciding when a precedent should be overruled. 5 factors discussed below weigh strongly in favor of overruling Roe and Casey. 1. The nature of the court's error. Like the infamous decision in Plessy v. Ferguson, Roe was also egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its error, calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elect representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who disagree with Roe. Second, the quality of the reasoning. Without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy, divided into trimesters, much like those that one might expect to find in a statute or regulation. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what is said about the common law was simply wrong. Then, after surveying history, the opinion spent many paragraphs conducting the sorts of fact-finding that might be undertaken by a legislative committee, and did not explain why the sources on which it relied shed light on the meaning of the Constitution. As to precedent, citing a broad array of cases, the board found support for constitutional rights of personal privacy, but Roe conflated the right to shield information from disclosure and the right to make an impairment important personal decisions without governmental interference. None of these decisions involved what is distinctive about abortion, its effect on what Roe termed potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with, among other things, the relative race of the respective interests involved, and the demands of the profound problems of the present day. These are precisely the sorts of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the courts provide the sorts of explanation that might be expected from a legislative body. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. The arbitrary viability line, which Casey termed Roe's central role, has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. The most obvious problem with any such argument is that viability has changed over time and is heavily dependent on factors such as medical advances and the availability of quality medical care that have nothing to do with the characteristic of a fetus, when Casey revisits Roe almost 20 years later, it reaffirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. The court abandoned any reliance on a privacy right, and instead granted the abortion rights entirely on the 14th Amendment's Due Process Clause. The controlling opinion criticized and rejected Roe's trimester scheme, and substituted a new and obscure undue burden test. Casey, in short, either refused to reaffirm or reject important aspects of Roe's analysis, failed to remedy glaring deficiencies in Roe reasoning, endorsed what it termed Roe's central holding, while suggesting that a majority might not have thought it was correct, provided no new support for the abortion rights other than Roe's status as a precedent, and imposed a new test with no firm grounding in constitutional text, history, or precedent. Third, workability. Deciding whether a precedent should be overruled depends in part on whether the rule it imposed is workable, that is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. The Casey plurality tried to put meaning into the undue burden test by setting out 3 subsidiary rules. But these rules create their own problems, and the difficulty of applying Casey's new rules surfaces in that very case. The experience of the courts of appeals provide further evidence that the cases lie between permissible and unconstitutional restriction has proved to be impossible to draw with precision. Casey has generated a long list of circuit conflicts. Continued adherence to Casey's unworkable undue burden test would undermine, not advance, the even-handed, predictable, and consistent development of legal principles. Fourth, effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling those decisions. Fifth, reliance interests. Overruling Roe and Casey will not impede concrete reliance interests, like those that develop in cases involving property and contract rights. In Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. Instead, the opinion perceived a more intangible form of reliance, namely, that people had organized intimate relationships and make choices that define their views of themselves and their places in society, in reliance on the availability of abortion in the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The contending sides in this case make impassioned and conflicting arguments about the effects of the abortion rights on the lives of women as well as the status of the fetus. The Casey polarity's speculative attempt to raise the relative importance of the interests of the fetus and the mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. The Solicitor General suggests that overruling Roe and Casey would threaten the protection of other rights under the Due Process Clause. The court emphasized that this decision concerned the constitutional rights to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Casey identified another concern, namely, the danger that the public will perceive a decision overruling a controversial watershed decision, such as Roe, as influenced by political considerations or public opinion. But the court cannot allow its decisions to be affected by such extraneous concern. A president of this court is subject to the usual principles of stare decisis, under which adherence to precedent is the norm but not an inexorable command. If the rule were otherwise, erroneous decisions like Plessy would still be the law. The court's job is to interpret the law, apply long-standing principles of stare decisis and decide this case accordingly. Under the court's precedents, rational basis review is the appropriate standard to apply when state abortion regulations undergo constitutional challenge. Given that procuring an abortion is not a fundamental constitutional right, it follows that the states may regulate abortion for legitimate reasons. And when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of viability. It must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate states' interests. Mississippi's Gestational Age Act is supported by the Mississippi's legislature's specific findings, which include the state's asserted interest in protecting the life of the unborn. These legitimate interests provide a rational basis for the Gestational Age Act, and it follows that respondents' constitutional challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogates that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. 今日讀公報帶大家認識咗美國嘅司法制度，唔知各位聽眾聽到幾多同埋覺得點呢？多謝大家收聽讀公報，我哋下次再見。